recusal practice, reforming the process of disqualifying judges for conflicts of interest. Now, obviously, the Caperton scenario is an egregious one, and I think it's also addressed fairly simply. States can adopt rules that say if a candidate receives a certain amount of money over a certain threshold, or if a party's contributions and expenditures in support of a candidate are more than 50% of the total spent in the campaign, that judge should step aside. States can and should adopt rules that try to sort of legislate different scenarios and dictate the results when judges need to step aside. But I would also suggest that campaign contributions are not the only scenario that gives rise to conflicts that require judges to step aside. And certainly in New Jersey, there's no issue with campaign contributions because there's no elections here. But there are still conflicts of interest that are going to emerge with judges here in New Jersey, and whether a spouse who's a director for a bank that's litigating before the judge, or a son or a daughter who was once a lawyer for the company that's litigating before the judge. There are any number of scenarios that can arise that should give rise to recusal when there's a conflict of interest. So the way I think of it is you have processes to select judges on the front end, and there are a number of different systems that are in use, and there are a number of different things that can be done to improve those systems, and then you have the results once the judge is on the bench. And you need a back-end solution, kind of a backstop, so that when there are conflicts that come into play in that judge's courtroom, you have methods of asking those judges to step aside. States are currently very actively considering different proposals. There are at least a dozen states that are considering amendments either to their statutes or to their judicial codes of conduct that would spell out in more clear terms what the circumstances are that give rise to conflicts that are worthy of disqualification. We published a paper last year. It's a big study called Setting Recusal Standards. Again, it's on our website. I can mail it to anyone who would like to get a copy if you don't have access to printing it from the web. And I don't think it's probably fruitful right now to go into a great deal of detail on all of the proposals. I will say a couple of words quickly, though. The proposals, I think, can be divided into substantive proposals, procedural proposals, and then proposals that get at transparency within the system. On the substantive side, obviously, proposals that say if you've given $10,000, the judge can't hear your case, those would be substantive thresholds. Those are useful, but I think the more useful reforms have to do with how requests for disqualification are handled, so procedural reforms. Some states, many states, have a process by which when you arrive in a trial court, you have one peremptory challenge. You have the opportunity to say no to one judge. So any party, for any reason, without explaining, can say, I don't want that judge. And they can do that once. And therefore, if there's an egregious conflict and that judge is, you have reason to believe that judge won't give you a fair shake, you can ask for another judge. One of the biggest problems is that these disqualification motions are frequently heard by the judge, him or herself, who's being accused of being biased. Now, think about that for a second. First of all, as I said before, Justice Brennan, had a long and lengthy deliberation in his own mind. So there's a problem, first of all, with having the judge who's been accused of bias thinking that through on their own without input from anybody else. There's also a tactical, I suppose you could say, challenge when a lawyer says, if this judge decides to hear the case anyway, what are they going to think that I just said they were unfair? Are they going to take that out against me when it comes to the second week of the trial? Are they going to rule against me about procedural things, what evidence I can introduce, and that sort of thing? So letting judges have the unreviewable power to decide their own motions is a big problem in the system. And I think whether by adopting a system by which another judge hears the motion, the request to recuse that judge, or having an opportunity for an immediate appeal if the judge says, no, I'm not going to recuse, having that go up to another panel, or having an advisory body, perhaps of retired judges who can weigh in on the facts of any given scenario. All of those, I think, would go a long way to making this recusal process function more smoothly and therefore improving the public's confidence in the fair, impartial nature of the courts. The last set of proposals we have to do with transparency and respond to the fact that all too often another problem that plagues this recusal practice is that judges don't have to say why they choose to recuse or not to recuse. They just say motion denied, and they continue to hear the case. And we believe at the Brennan Center that having judges be forced to, on the record, disclose all the facts that are relevant and explain their reasoning why they choose to recuse or not would be extremely useful. So we have called on states to adopt requirements that judges explain either in open court on the record or in writing what their reasoning is with respect to these recusal requests. And finally, we've asked states to collect data. If states collect data on the number of recusal motions that are filed against particular judges, what happens to them, how they are decided, we believe it will enable researchers to look at what works and what doesn't work, and it will enable states to identify the sort of most effective best practices and implement those in their own states. So those are, again, expanded in great detail in our report that's available on our website. I don't think it's worth me going into too much more detail about them, but I think that would be an effective means by which states could legislate improvements to the way their systems function so that some of the egregious conflicts of interest that currently are allowed to persist and currently, I think, undermine the public's confidence in the role that the courts are playing would be addressed. And so, as the Brennan Center has for several years now, I would commend the states to reform their processes in this area. So that's, I think, the comments I'd like to share with you tonight. I certainly appreciate all of your attention and time, and would be happy if anyone has any questions about anything I've spoken about tonight to do my best to answer them. Sir?
Listen, that case, first of all, keep up the good work. I mean, full power to you.
Thank you.
We need more investigations like that. In the Caperton case, were the 4 Supreme Court justices the same 4? Scalia, Thomas,
Roberts, and Alito.
Always vote together?
Well, there are a couple different sets of 4 that always vote together, but they were the justices that were in dissent in the Caperton case were Chief Justice Roberts and Justices Alito, Scalia, and Thomas. And Chief Justice, and there were a couple of different dissents that were joined by some of the different justices. Chief Justice Roberts wrote the primary dissent, and his basic issue was, look, this may be a really egregious problem, but this rule that you're suggesting that due process is offended is going to be really hard to figure out. What if those contributions were made 3 years ago, not last year? Would that change the thinking? And so he went down and said there are 40 questions that this rule leaves unanswered, 40 questions that are going to be very difficult to administer. And those are valid points. And one of the reasons we encourage states to reform their processes is so that some of these scenarios can be dealt with at the state level before it becomes a federal constitutional crisis.
May I take exception to some of the things?
Please do.
Oh, okay, but on many things, but diversity. But before I ask you about diversity, is Brennan D. William J. Brennan?
It is. It is, in fact.
Okay, so we know where we're coming from.
I think that's right.
Yes. So let's take diversity. You use the words wrong and egregious. That's a point of view, right?
Absolutely.
Point of view. I might point out, for example, like say, how far do you carry diversity? Does it go beyond, what you talk about, white men, Latina women? Are white men divided into, are there Baptists and Methodists? For example, if we look at the U.S. Supreme Court, take black people, they're within proportion, right? You have one justice, 11% of the court, and the black population of the U.S. is about 13%. But if we look at the other people, the court has Jews and Catholics overrepresented. Do you go that far?
Well, I think it's a very valid point, and I think that...
I might point out that the U.S. Senate is that way, too.
I think that's absolutely true, and I would certainly resist and would not support any sort of quote